Hello, good morning, good afternoon, good evening. I hope you're all doing well. This fine Wednesday, the 2nd of July. Well, almost Independence Day for you guys in the States, isn't it? Except Bryan Kohberger. Bryan Kohberger ain't going anywhere. He has 0 independence left for the rest of his entire sorry little life. And in about 15 minutes' time, the hearing to change his plea from not guilty, even though, do you remember back in the day when Bryan Kohberger had his original plea hearing and he didn't speak? And it was Ann Taylor who stood up and said, I think it's called standing in silence. And Judge, as was then, entered a not guilty plea because Bryan Kohberger chose to stand silent. That said a lot to me. That said a lot. Anyhow, here we are, because a couple of days ago, as you know, Bryan Kohberger decided to take a plea deal. The Gonzalez family, Kaylee's family, are furious. I mean furious. They've been posting on their page. I'm going to show you the latest post in a moment. And they are absolutely fuming. The Chapin family, I think it's been said, although I don't think any of them are actually spoken, that they're in support of it. Maddie's dad has been interviewed and he's also in support. Xana's aunt has spoken and she's not in support of the plea deal, but we don't know about Xana's parents. So the families are somewhat divided, but the Gonzalez family have been the most outspoken of the 4 families, and they are not having it. They are not having it. They're appealing to the judge. And look, I feel for them. I really do. I feel for them. But I guess there is some satisfaction of going through trial, hearing all the evidence in front of a jury, and then having that jury convict the person that killed your child. I get it. I absolutely 100% get it. But the fact that Bryan is choosing to plead guilty just to take the death penalty off the table, he's not doing this for anything else other than he's scared of dying. How ironic is that? But I think the fact that he's pleading guilty has got some positives because it shuts down the conspiracy theories. I mean, look, the pro-burgers, they're all out. I've seen some of it. They're all out saying this is a false confession and he's been coerced and all this and all that. Okay, you can go with that if you want to. You can say that if you want to. But if he'd been found guilty at a trial, then there would have been the ability to appeal. There would have been, especially in a death penalty case, he's got an appeal. Like you don't even have to appeal for an appeal. You get an automatic appeal if you're found guilty and the death penalty is imposed. So there would have been years of litigation. There's no guarantee that the jury, even if they convicted him, would have gone for the death penalty anyway. So if the Gonzalez family are up in arms because the death penalty has been taken off the table, well, they may not have gone for it anyway. The jury may have decided that they'd rather see Kohberger rot in a jail cell for the rest of his life. They may not have gone for the death penalty. But even if they did, it would be years, many years before he faced the firing squad. He would have had an appeal and then another appeal and then another appeal, and it has just gone on for years. So there is a lot of benefits for this, where we are right now. There's a lot of benefits for it. But I do feel for him. I do. Life in prison will be hell for him. All right, say a couple of hellos, and I'm going to show you the latest post from the Gonzalez family. Hello, Lisa. We got Holly. We got Angie, baby. We got Yvonne. We got Melissa. We got Paper Chaser. Yeah, my upgraded tech. Hey. He was coming. Ben, my technician, he even gets a name, was coming between 1 and 6. And I thought, yeah, they've organised this change of plea hearing, and I'm going to get my internet switched over right before 6 o'clock, and I'm going to end up not being able to stream it and not being able to watch it live. Anyway, it came at 2, so it took him about an hour. He had to do cables and and drilling and stuff, but it's all working great. And I tell you what, right? I did a test and a 2 gigabyte video. So my videos that I make, the recorded videos, they're usually about 2 gigabytes. Like a 15-minute video is usually about 2 gigabytes. And it takes about an hour normally to upload. So I did a test and I was able to upload a 2 gigabyte video in 3 minutes. What? It's not on the channel, don't worry. It was just a test. Like, I deleted it. I just uploaded it in private and then deleted it because it was just a video that I'd already uploaded. It was just a file that I've already got. So, upgraded tech is, I'm all for it. I'm all for it. I've not been able to have full fibre before. It wasn't available in my area. And then it just was. So it's like, oh, I'm grabbing that. And it's also cheaper. Because I'm on a deal. It's also cheaper. It's like, it's going to be like 20 quid a month cheaper. It's insane. Hello, Shazza. A few money more. Oh, you got a meeting? No. I used to hate those days when you got a meeting at a time when you got something else. Hello, Amanda. We got Dawn. What else we got? Amy Lou, CW. Be listening in. Mucking out the horses. Oh, yes, 6 o'clock is mucking out time. All my boys, Donna, Linda, Nikki, and a few more people. All right. So let's make this a little bit bigger. So this is Court TV. It's on in the background, so we'll know when the court goes live. So this is the Gonzalez family page on Facebook. And this is the latest post from a couple of hours ago. And this is very strongly worded. Right here, right now, we dig our heels into the earth and carve a line deep in the dirt. This ain't justice. No judge presided, no jury weighed the truth. Thompson, so that's the guy who looks like Santa Claus, robbed us of our day in court. No negotiations, no jury of our peers, not even the pretense of cooperation and fairness. Cowardly men, gutless men, they scatter like roaches when the battle closes in. And Thompson, he's retiring on this deal. His shadow slithering towards the exit, leaving only the stench of his betrayal. I told you this was strong. No spine, no shred of honor. He didn't have the basic decency, the plain human courage to face the families, to meet our eyes and ask, how do we make an offer that works? There wasn't much they could offer. The only thing they could offer for a quadruple murder, the only deal they could broker would be to take the death penalty off the table. That was it. He was always going to get life in prison. I mean, what other deal could they offer him other than taking death off the table? That was it. That's it. That's all. Instead, Thompson cut his deal with the devil. His negotiations didn't require anything other than a simple guilty plea, allowing him the leeway to blame the same people you are paid to protect. You betrayed us, Thompson. Your deal fails to shield the innocent. You could have stood tall and made damn sure the blame stayed where it belongs, not on us, not on the broken survivors still carrying the weight of your repeated failures. Don't know what's been going on behind the scenes now. What we've heard is that on Friday, the families were asked, were contacted and asked their opinion on the idea of a plea deal. So it was like a hypothetical, but then they just went ahead with it. So it did knock the family sideways, given that we're only a month out from trial, that it was a done deal. Like on Friday, it was just a possibility, and now it's a done deal. But you see, the thing is, not all the families are standing with the Gonzalez family. So if you say, well, okay, the family's got a right to choose and they should be involved as an active party, well, that's not how the law works. But in a case like this, where you've got 4 different families and not all of the families are in unison with the Gonzalez family, well, who gets the final vote? Do you know what I mean? But it's not how the law works. Unfortunately for them, and I do feel for them, it's not how the law works. And there's a lot of benefits of Bryan Kohberger taking a plea deal, because however strong your case is, there is always that possibility that it just takes one juror to not agree and to say, no, I'm not voting guilty. It takes one jury to hang the jury, and then it's a retrial. So you've got to go through it all again. You know, we've just had it with Karen Reid. You've got to go through it all again. It's at least another year of pre-trial hearings and fighting, and then the trial. You've got to do it all again. Is that really what they want? Is that really what they want? I don't think anybody really would want that. I really don't. Given that, you know, they're going to show the autopsy photos, there's no rest. There's no rest for these victims at all in those circumstances where you've got a mistrial. And mistrials can be caused by other things other than a hung jury. So it doesn't matter how strong your case is. There's always that possibility that something's going to go wrong. So having the guilty plea in the bag and then just sending him off to a state prison somewhere and letting him rot until he dies, that's the best anybody's going to get. That is the best anybody's going to get. Because look, even if all went well and, you know, the trial went well and he was convicted and they got the death penalty, he's just going to sit on death row for at least another 20 years. People are on death row for years. It's not like the old days where they literally just, you know, found you guilty, take you out the back and hang you in front of a crowd of people. It doesn't work like that these days. It doesn't work like that. I mean, look how long some people sit on death row. And yeah, it's not pleasant being on death row. You know, you don't get certain perks that you get when you're in, you know, Gen Pop or even some kind of protected pod. You don't get all the same perks. Life is harsh on death row, but it's still life. You know, there's still stuff you can do. And it means that he's still there. He's still there in the world. I get it. I'm a supporter of the death penalty in extreme cases. Not in every case, just in extreme cases. I do wish that we had the death penalty here in the UK. I think we're far too lenient on the most serious of our criminals. I think we're way too lenient. Anyhow, that's just my personal opinion. This is our courtroom now, this moment, this stand. Our voices rise to every American who will listen. We would have provided protection for the roommates, the best friends, the fallen vet, God rest his soul, and every soul affected in our shattered community. We would have carved our terms like sacred commandments, etched deep into unwielding granite, a testament to those we've lost and the justice they're owed. We've got this screen here on Court TV. Court will resume shortly. So we are on the hour now. So I'm going to just check that my volume's on. Yeah, my volume's on. So I'll hear it as soon as it comes on. And I get that maybe the deal that they would have wanted would be for Kohberger to say why he did it, who he targeted, where's the weapon, you know, those kind of things, and to give a full account of what happened. But there's no law that would demand Kohberger did that. The judge could ask, but the judge can't force him. to say what his motive was, they can't force him to do that. I know some people think they can, but they can't. They can't force them. They can ask questions, but they can't force an answer. And whatever answer he might give, it doesn't necessarily mean he's going to give the answers. I think Kohberger is so devoid of emotion, he's so in his own little self-centered world, that he's not going to want to help the families at all. He's not going to want to give the answers that the families seek. And that's tragic. It's an absolute tragedy, but this is what a psychopath's like, unfortunately. First, the truth, spill it, BK. Every sickening detail only the killer would know. The kind that twists your guts just to hear, but turns even a simpleton Kohberger against you. I can tell Steve wrote this. Second, you bear the guilt, all of it, alone. You don't get to smear the survivors, the ones still waking to nightmares born of your reckless choices. I do agree with that. But you see, the thing is, Kohberger doesn't have to say, I did this alone. It would be nice if he did, but he doesn't have to. They can't force him. Third, no cashing in on our grief, no books, no private interviews with your ex-professor. No one is allowed to study you because you're not special. You don't get to spit on our kids' graves by making this all about you. I agree, no profit to be made off books, but I think that's the deal anyway, isn't it? That prisoners are not allowed to profit off books and movies and stuff like that. I don't know, like that kind of law, that civil law, don't really know, but I believe that's the case. Studying him, I don't have a problem with that, because when you study these people, yeah, it gets their names out, the names are remembered, the names are in journal articles, the names are in forensic psychology textbooks. But studying them helps understand the mind of these people. So if no one ever studied the worst of our worst in society, it'd be bad. It'd be bad for science. Only Hitler can step into this void, mend the wreckage Thompson left in late our so-called justice system. This is what murder victims' families' negotiation look like. It's ugly, it's raw, it's wild, it's anything but easy. Yet you, Mr. Thompson, didn't even bother to negotiate with us. So this is all we have left. There is no more time for us to wait for you to make a stand. So we stand in your place. Kayla J. Gonzalez, we love you, baby. You deserve better than this justice system. Your soul is not Thompson bargaining chip. We do not accept his plea deals signed in your name. We're screaming for you as loud as we can. Kayla Jade is better than this. This is our last shot. Judge Hitler, you are our only hope that our child murder isn't granted. It's horrible, this. Control over his destiny in our child's names. You take control of this deal and make it right, because you now own it. Oh, dear. I mean, there's pain in every sentence. There really is, but seeking all the support we can gather. So there's a link to contact the United States Department of Justice. I mean, it's just painful. Painful. Death penalty is merely an illusion in the criminal justice system. When available, it serves as a bargaining tool for the state, and when rarely applied, it's never enforced due to a highly efficient appellate process. Yeah. But if you're sentenced to death, I do think you have the right to appeal, because sometimes juries get it wrong. We've seen this with Delphi. Sometimes juries get it wrong. So when someone is sentenced to death, I think you have to be as sure as you can be that the verdict is just. And of course it's a bargaining tool. Of course it is. Of course it is. Rightly or wrongly. The notion that someone can plead guilty to a crime and still face years of appellant delays reveals a systemic failure. The Leto County Prosecutor's Office treatment of our family during this process is something I wouldn't wish on anyone. You see, there's a lot, I'm sure there's things that has gone on behind the scenes that they've not been able to talk about that have angered them, and this is just the final straw. I would imagine, like reading between the lines here. We questioned decisions early in this investigation. Why was the mayor commenting on the case? Why was the coroner speaking to families? Why was an officer with less than 2 years' experience leading the investigation? Why was the University of Idaho involved when they declared it an isolated off-campus incident? I said this very early on. And the reason is because the University of Idaho, any university, when you live in a university town, it's a lot of money. The universities have got a lot of power. They've got their little fingers in all sorts of pies. They've got a high level of control. Believe me, because I worked for 2 different universities over a period of just over 20 years. I know what power university management have in the town because they have they employ a lot of people. They bring in a lot of revenue. And Moscow, Idaho, it's a, you know, in term time, when the students are there, just imagine how much trade is brought into Moscow, Idaho. And if the University of Idaho disappeared, Moscow, Idaho would lose a lot of revenue. It'd lose a lot of jobs. That's only one reason why universities have got a lot of power. It's only one reason, but it's the most obvious reason. It's the most easy to talk about reasons because it's the old boys network. It's silly handshakes and the Masonic Lodge. Believe me, certain things you can't talk about, though, not easily, without being called a crank. But I've seen it. Please believe me, I've seen it. All right. Why was the university permitted to write a book about the incident while others were silenced under an overly broad order? I didn't know that the university did write a book. I didn't know that. As a result, we were branded adversaries. So it's no shock how the Leto County Prosecutor's Office mishandled the plea deal. We still got this. So, okay. Leto County should be ashamed of its prosecutor's office. Oh, okay. They vaguely mentioned a possible plea on Friday without seeking our input. Presented the plea on Sunday. Leto County should be ashamed of its prosecutor's office. 4 wonderful young people lost their lives, yet the victims' families were treated as opponents from the outset. We weren't even called about the plea. We received an email with a letter attached. That's shocking. That is shocking. At the very least, the prosecutor's office should have called them all, at the very least. I know they're not all local, so inviting them all in for a meeting maybe is difficult. But, an actual conversation, like a Zoom meeting. How about using some technology and a Zoom meeting? How about that? But an email, no, come on. Come on. That's like breaking up with someone by text message. It's cowardly. That's how Leto County Prosecutor's Office treats murder victims' families. Adding insult to injury, they're rushing the plea, giving families just 1 day to coordinate and appear at the courthouse for a plea on July the 2nd. Yeah, because they don't want Kohberger to change his mind. They're doing it quick because they don't want him to change his mind. Who do you think they are? After more than 2 years, this is how it concludes, with a secretive deal and a hurried effort to close the case without any input from the victims' families on their plea details. Our family is frustrated right now. That will subside, and we will come together as always and deal with the reality that we face moving forward. Once again, we thank everyone for their thoughts and prayers. So that was yesterday. Painful. Painful, painful, painful. Really. Do you think if the death penalty was on the table in the Delphi case, we probably would have gotten a plea deal? We got all the nonsense because there was nothing to lose. Okay. Well, why did they not go for the death penalty in the Delphi case? I've always wondered that. I don't know the answer. You know, you would think, because Indiana does have the death penalty, don't they? I'm sure they do. Hold on. Let me check. Does Indiana have the death penalty? All right, yeah. Indiana does have the death penalty, capital punishment. Okay. All right, so apparently, according to AI, it does. Death penalty information center. Death penalty has been present in Indiana for much of the state's history. Capital punishment is legal in the state of Indiana. All right, so it is. Yeah, so why? It's an interesting point. Why did they not go for death in the Delphi case? Is it because death penalty cases, they're under much more scrutiny? Maybe, possibly, because they had a very weak case. They didn't want the scrutiny. I don't know. Don't know the answer to that. Don't know the answer to that. An email is shocking. Absolutely. Absolutely. Kohberger's family feels. Well, apparently they've never been to see him. I don't know whether that means anything because they're right the ways over in Pennsylvania and he's in Idaho, opposite side of the country. But you would think, you know, in 2.5 years, even if you were strapped for cash, you might have been able to get the money together to get a budget flight out there to go and visit your son in prison or in jail. Maybe they call him. I don't know. We've never had any information about Kohberger's jail phone calls, so we don't know. Can they make it part of his plea deal? What, making him say what happened? They can try, but he doesn't have to tell them. And listen, he could, you know, when you force people to speak, the chances are that if they don't want to speak, but they're being forced to, they're going to tell you a load of nonsense. They're going to lie. So even if he does explain why, how do we ever believe him? I mean, he could say where he put the knife. That, you know, there's certain things that he could say and how he did it, who he killed first, and then they will know the order in which they were murdered because they were all murdered with the same knife. So you've got transfer of blood and body materials. So the first person who's murdered has no other victims' DNA, blood, body materials on their body or in their wounds. Then the second person who's murdered will have the blood or DNA from the first person. The third person will have victims 1 and 2, and then the last person will have all 3 other victims. Oh, here we go. Here we go. All right. Muting out, guys. Muting out.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and pardon me, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms.
Your
Allen
Honor.
is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this, because again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. but the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that you so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with, that I understand you're going to plead guilty today to?
Yes.
As as I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Is anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count 3, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count 4, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing in his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m. on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Caitlin Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom were to see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th, 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. You can try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogen, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you. All right, based on the state's proffer, and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, pardon me, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. Court finds that there is a factual basis for the plea, and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor. Thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through
All right.
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else to say?
No, Your Honor. Thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
Well, there we go. It's short and sweet. Done deal. I don't think that he was doing it because he was coerced or any other nonsense that... Oh, what's going on here? What's this? What's it taking us to? What has it even taken us to? That is bizarre. Yeah, let's not go there. No idea what that was about. But look, if people want to still maintain that Bryan Kohberger is innocent, that's fine. Who am I to judge? Who am I to judge? I've always thought they got the right guy. Of course, he was constitutionally innocent until proven guilty, or until he intelligently and consciously gave his guilty plea, which we've all just heard. Well, there is a difference between being constitutionally innocent and being factually guilty. So I've always maintained that he was the right guy. And I've always maintained that if they let him go, he would do it again. And I think he was hoping that he could be the next Ted Bundy or BTK or any of the other serial killers that are talked about, you know, in university courses and textbooks and on podcasts and documentaries. That's what Bryan Kohberger was hoping that his life would become. And he made a fatal mistake by leaving his DNA on the knife sheath. I heard someone, I can't remember who it was, who gave me pause for thought. I genuinely can't remember who it was. It was quite recent. Because I'd always thought that leaving the knife sheath was a mistake, that he was panicking because he didn't expect there to be two victims in one bedroom, and he was panicking a bit. We know that Kaylee fought. We've heard that from Steve. And it could well be that he just dropped the knife sheath. It wasn't secured properly, or maybe he was holding it, and who knows. But then someone said that maybe he left that knife sheath on purpose, and that was going to be his calling card, that every time he committed a murder, he would leave a knife sheath, so it'd become known as the K-Bar killer. And that makes sense, the fact that he was looking to buy another K-Bar knife. Now, maybe he was looking to buy another K-Bar knife afterwards, so that if the police did come knocking, he could say, well, look, here's my K-Bar knife and here's the sheath. But I don't know. I think he was maybe thinking that he was going to use that as his calling card, and that he'd become known as the K-Bar killer. And that gave me pause for thought. And I thought, yeah, maybe. We'll never know. Unless maybe he wants to do an interview, you know, maybe he wants to speak. Maybe he'll agree to be interviewed and he'll tell all. Who knows? Who knows? But if he doesn't, then we'll never know. We'll never know any of these things. And there will be things that the victims' families and the public in general are never going to know. There's always going to be questions, and whether it doesn't matter whether it's went through trial or whichever, you know, route we got there, there's always going to be questions remaining. But the K-Bar killer does have a ring to it, And I maintained from the beginning that if they let him out, he would do it again. He would. That kind of person, he would do it again. And the fatal mistake was, if he intended to leave the K-bar knife sheath, that he didn't fully wipe it. But I bet he wore gloves while he killed them, and he thought that he cleaned all the DNA off that knife sheath, and he left it. He just missed a bit. He just missed a bit. And I think the pains that he was going to once he got to Pennsylvania, you know, the fact that the interior of his car had been pretty much disassembled, that's crazy. I assume he'd just taken everything out to clean it. And the fact that he was putting trash in neighbors' bins, I think he knew they were onto him. I think, or at least he was panicking that they were onto him. I think he was become very, very paranoid, and rightly so. The other mistake he made was turning his phone back on. Absolute. Yeah, K for Kohberger. Yeah. The K-bar killer. And there you go, K for Kohberger. Yeah, that's a good point. And he turned his phone back on. Why? Why would you do that? Why would you even take your phone with you? It's ludicrous. But yeah, he made some mistakes. But you could guarantee if they let that guy out, he'd do it again, and he'd do it better next time. He wouldn't leave a witness, and he'd do it better next time. So I'm glad that he can never, ever, ever see the light of day again, other than from a prison yard when he's getting his mandated hour of exercise. That's the only time he's ever going to see the light of day ever again. It will be from behind the walls of a prison yard. Thankfully. And there was always that risk that however good the case was, that something would go wrong, jurors wouldn't take to the evidence for whatever reason, and he'd get a not guilty. I don't think it would have happened in this case. I really don't think it would have happened in this case. I think the state's development of the evidence and the way that just bits and pieces of things fits into place, and you've got the biggie, you got the DNA. I don't think it would have been a not guilty. I really don't. But there was always that very small chance. And I was just thinking, if it goes wrong and he gets let out, he will do it again. And he'll do it again soon. But we don't have to worry, because he's admitted to it all. Very matter-of-factly. Did you hear Mr. Thompson's voice breaking at the end when he said the names? Maddie, Kaylee, Ethan and Zanna. His voice was cracking. Bryan Kohberger's voice wasn't cracking, was it? Like, speaking clearly, loudly, matter-of-factly. Yeah, just flat, emotionless, just matter-of-fact. No emotion at all. Nothing. He's just an empty space. He's just flesh and bones and a big empty space. That's all he is. He's just a human being that's just a void, an emotionless void. So good luck to him in prison. I think he'll be in a protective pod, I would imagine. He is an incel, definitely. I said even before Kohberger was even caught that it would be some kind of weird incel type person. just by the nature of the victims. And I believe, just personally, I believe the target was Maddie. I used to think the target was Kaylee, because Kaylee had talked about having a stalker. But I can't think at what point I changed my mind on that. And I thought, no, the victim is the actual victim was Maddie. And maybe it's because she worked at the Mad Greek and they got a vegan menu, and just maybe he saw her. Why he chose that house? Was it the house? Was it Maddie? It could well have been that he was just looking at the house. He was looking at houses where students lived. And the house is perfect because you've got that parking area around the back. You've got the, you've got that tree line that shields like the vision. And if he's cruising the streets, 23 times, his phone connected to the Moscow Tower near King Road. And he would have learned that there was off-campus housing, and maybe he saw young women coming and going from that house. Who knows? Who knows? Again, something else we'll never know unless he wants to tell us. Unless he wants to tell us. We'll never know. I do think Xana and Ethan were collateral damage. I think the fact that Xana ordered the DoorDash. I think maybe if Xana and Ethan were both asleep, maybe they'd never have been targets. He'd never have gone into their room. But because Xana was maybe, I don't know, maybe putting her food away or whatever, she was up and about, she encountered him, and he, he knew she was there. But Ethan was asleep. Ethan was sleeping. That's just crazy to me. It's crazy to me how he murdered Ethan, who was asleep. Maybe Ethan woke up. Maybe he was asleep. He was in bed, but he kind of woke up. Maybe he shouted Xana, like he heard Xana. He heard, commotion, and he maybe just aroused, it roused him just enough for Kohberger to notice him. But that is the ultimate in cowardice. Like stabbing someone to death in bed. It's the ultimate in cowardice. The whole thing is just a coward. He's a coward. He's a coward. The video that I made the other day and the thumbnail put coward on it because he is. It's just a cowardly act. Like murdering people when they're asleep. Like driving round and round and round the neighborhood until the lights go off and they're asleep. Cowardice. What? Thompson said there was no hint of a sexual motive. There was no signs of sexual assault because his kick is actually in the killing. Like whether he got a sexual thrill from it or not, and it doesn't matter really, does it? The intent was to kill, not to abuse. It was to kill. That was it. Clean and simple. It was to kill. But how Dylan got away, like Dylan came out of a room. I think once it got to a point where the energy it must take, the adrenaline it must take to kill 4 people, when you actually only intended to kill 1, I think he probably was just completely like zoned out and maybe didn't even register that Dylan was stood there. She is so lucky. That girl has a guardian angel. She is so lucky to be alive. Probably doesn't feel it. She'll have survivor guilt probably for the rest of her life. And the way that the internet has treated her is just absolutely horrendous. But she'll have survivor guilt. She absolutely will. But she has a guardian angel. She does. But yeah, there we go. Done deal. So sentencing. What did he say? Did he say 23rd of July? Still trying to understand his motive. Yeah. Well, gets a thrill out of killing. I think he'd studied serial killers. I think he was obsessed. I think he chose girls because he's a coward and because he's an incel. And he chose a group of people who were living their life. They're young, they're beautiful, they've got the whole lives ahead of him. He sees them, he sees the type of life they're living, he sees the type of fun they're having. He can't have that. He's never had that. He could never get a girlfriend who looked like that. So you've got all of this obsession and I don't know what the word is, just emptiness. And he takes it out on a group of people who are sleeping. That's what he does. So maybe there wasn't a target. Maybe it was the house. I did a video way back. Was the target the victims or was it the house? Like that, you know, he'd looked at various houses and that was just a perfect house. You know, we may never know. We may never know. Yeah, pent-up frustration. But it's not like a pent-up sexual frustration as much as a pent-up frustration of his life, of him. And maybe he thought that, you know, giving people agony and having the power to take people's lives, it makes him feel good. And why we get this absolutely obscene, given what he's just done, like a couple of hours before, like 5 hours before, given what he'd done, he's on his own in his apartment, one of the only times I've ever seen the guy smile, and he's giving a thumbs up to the camera. That says it all. That he feels powerful. He feels good. It's probably given him an emotional response that he can't have any other way. Yeah, it's smug. He's smug, yeah. He's feeling good about himself for once in his life. But he'd want that again. He'd want that feeling again. And that's why, if they ever let him out, he'd do it again. He'd go straight to it. I believe that totally. So the fact that we're going to get a guy behind bars for the rest of his life makes the United States a little bit safer. Just a tiny, tiny bit safer. Anyhow, he would chase that rush, yeah. Because imagine that, you know, you're in an emotional void. You're just empty. And you find a way to give yourself a thrill, to feel powerful, to feel you've got this potency. Potency, is that the word? And you'd want that again, wouldn't you? You'd want that again. Maybe you'd feel chilled out. Maybe you'd feel good for a while. And then maybe you'd be paranoid maybe as well. But you get a few months down the line and nothing happens. No one finds you. You're getting a kick out of seeing it all over the news. You're getting a kick of people wondering who this person is, not being able to work out the puzzle. And then he'd do it again. He'd get that need again. And he'd do it again. And then he'd do it again. And then he'd do it again. And we'd have a serial killer. We'd have a serial killer. For, you know, very different reasons than some serial killers operate. But still, that's what we'd have. So that knife sheath, whether it was a mistake or whether it was intended to be left there as a calling card, and he didn't quite clean it well enough, that ultimately was I think the nail in the coffin that I think the jury would have needed to convict him. But hey, all right, guys, gonna go. That was a good one. One in the bag. Horrible, tragic. But at least he can't do it ever again to anyone else. You've got to take that. We're going to take that as a win. All right, I'm going to sign off. Thank you for joining me. And next time we see him, we'll be at sentencing. And I don't think Judge Hippler will give him anything other than what has been stipulated in the plea agreement. Like he did say that he could give lesser charges. I don't think he will. I don't think he will. I think it'll be 4 life sentences without the possibility of parole. There's nothing else he can do. There's no way he'd say life with the possibility of parole in, I don't know, 30 years or 40 years or whatever. No, it's not going to happen. It's not going to happen. The only other way he could go would be to allow him to serve his 4 life sentences concurrently. So basically all in one, rather than consecutively, which is one after another. But if you've got 1 life sentence without the possibility of parole, well, you can't actually lead 4 lifetimes, can you? So he's a goner, and thankfully so. All right, guys, thank you for joining me. Thanks as always to the mods. Don't think I had any donations, did I? No, that's okay. All right, I'll see you very soon. Enjoy the rest of your day. Signing off. Bye, guys.